Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. My name is Thomas Vick, and I'm joined as always by Seth Wilson of Adler Attorneys. Seth, how are you doing today?
Thomas, I'm doing great. It's good to see you this fine Friday afternoon on the last Friday of April. My goodness, can't believe we're almost to May, which is always a fun time of year around Indianapolis. 500 coming in and getting ready for end of school and all that kind of stuff. So
And the mini
good time
marathon,
of year.
the mini marathon, which I'll be running here in the next uh, 2 Saturdays from now.
Awesome. Well, how's the training going? You ready to
Uh,
go?
I've only been lying on the ground on the side of the road a couple times, but other than that, it's been pretty good.
Well, it's good. And when you run something like a mini, you need a plan. And obviously, we talk a lot about planning in our podcast here. So it's kind of fun to think through that and see how those minor plans connect with your major plans. So one of the topics I wanted to talk with you about is sort of what are, if somebody has never set up their estate plan before, what are some of the main things that you want to know or think about as you're setting up your plan for the first time?
Well, first of all, a will is good, but it's not enough. You need more than a will, especially if you have other assets to contemplate besides like a bank account. A will is not enough. For instance, if there are retirement accounts, a person needs to think about, well, what are the beneficiaries of my retirement accounts going to be? Um, a will not govern what happens with the beneficiaries of a retirement account or a life insurance policy. Generally speaking, the whoever you name as the beneficiary is going to be the one that receives that regardless of what the will says. And so it's important to understand that a will is a good first step, but you need to go a few steps further and make sure you're taking care of your other assets. That's one of the things that you need to keep in mind. You have anything on that as well, Seth?
No, I just always counsel folks when we're meeting to say, look, if you're thinking about all of these issues, it is a time to review all of those beneficiary designations and understand which accounts may have a payable on death part of them, or a transfer on death, whatever terminology the bank may use, as well as understanding what accounts may not have that capability. Because if you don't bring those back into the estate properly, then those funds can cause some challenge for your beneficiaries down the road. And so it's really good to kind of get a good big picture view of all of your assets and accounts. I found too that folks will sometimes remember an account that they thought they or forgot that they had in terms of maybe a rollover from a prior job. And there may not be a significant amount of assets in that account, but this is a good time to say, oh, I didn't ever put a beneficiary designation on this when it rolled into the new account, or I didn't know even how to access it. So it's just a good time to do that and kind of make a list of there and get your financial house in order a little bit.
Yeah.
So when you are, go ahead, Thomas.
Yeah, and then when you're actually doing a will, another thing to keep in mind is you have to name an executor, and the more common word in Indiana is a personal representative of your estate. And that's the person that's going to be in charge of administering your estate. They sort of step into your shoes after you have passed away, and they'll, make sure that bills are paid and then eventually distribution is made. And so naming the right person for that job is an important part of the estate planning process.
Agreed. And typically you'll see if in a spousal situation, either spouse will serve for the other one. And it can sometimes be good to have a backup named in the event that something happens to both spouses at the same time. And so thinking those ideas through as well are good considerations as you're working through this process for the first time. Thomas, I really appreciated this sort of explanation in your blog digest today about the assets that get a step up in basis This is tax terminology, and so this right up here, walk us through that if you would, and then if folks have more questions, I would direct them back to the blog itself to kind of read through and understand some of the different issues when we're talking about basis.
Yeah, so stepped up basis is a way to save taxes, to put it simply. If you have stepped up basis, you won't have to pay taxes on the sale of real estate, for instance, whenever it's sold. If you've got a house and then you decide that you're going to put an adult child who does not live at the house on the deed, and then you pass away and your adult child is now the sole owner of it. When the adult child goes to sell the house, he or she is going to have to pay capital gains taxes on whatever the gain on that sale of the house is. So if you purchase that house for say $50,000 and then they sell it for $100,000, that adult child is going to have to pay taxes, roughly speaking, on $50,000 of gain. And so that can be a tax burden that an individual really didn't intend to have to place on somebody. And we talk about, options of planning. One of the options there is to put the house into a trust, and then the house will just go to the adult child through the trust. And you might even put that adult child as a co-trustee on it if you feel comfortable with that. But that's a way of preserving that stepped up basis so that you're not having to put a tax burden on the succeeding generation. So that's an important thing to keep in mind when you're going to do your estate planning.
Yeah, and that's a good reason to kind of make that inventory of assets and accounts and think through when those are transferred and how they're transferred and what are sort of these other considerations that may take place, and whether or not it's kind of gets us into our next topic is, what about a life estate or a transfer on death type scenario for real estate, and how does that affect that transfer tax, if you will, of the step up in basis?
Yeah, so the life estate can be an effective means of transferring the property from one generation to the next. It kind of ensures that a certain person or certain persons receive the property without the burdensome taxes that come along with that. Um, and then also, it can provide some form of asset protection. It may not be the best option, but it does provide a little bit of some asset protection. And the main thing is, if there had to be, if somebody got into a creditor situation and the house had to, maybe there's, business litigation that goes sideways, or, a car accident, and there's more damages than insurance to cover, you could get into a situation where maybe real estate needs to be sold and the proceeds, given to somebody, which would be a terrible situation. But if there's a life estate, that life estate isn't going to have a whole lot of value to it. Because you're only going to, if somebody purchases that life estate, and the person is expected to live maybe 10 years, well, they're only going to have, 10 years to live in that house, to use it, or what have you. And so it's a way of protecting assets to some degree. But there may be some better options if the ultimate goal is just to transfer the property to, adult children.
Yeah, and it's an interesting tool that's been around a long time, right? And it kind of breaks up the property into two different types of interest. One is that possessory interest, and then there's an actual ownership interest, and that's where that asset protection can come into being in certain ways, like you said. And so it's an interesting way to give somebody the right to retain that possession and use but you can also do that in other ways. So one way we've done that and some of our planning is with a right of occupancy trust for a residence, for example, where you can set out the terms and conditions on which someone can occupy the house for a period of time. And there may be different reasons for that. And there's some flexibility there in terms of who's going to pay what. So is the individual who is in the residence responsible for paying upkeep and the mortgage and those kind of things, or is the trust going to do that if it's maybe for someone who is a minor child until they turn 18 and you want to keep the house in the family kind of thing. So there's lots of different options there. And then the transfer on death piece of this is pretty interesting from a deed perspective, right? So that wouldn't take place until the individual owner or owners pass away, and then that property ownership transfers at that time via the inheritance. And that also addresses that stepped up in basis issue, which is pretty neat way to do things. So
Yeah.
how have you used that in your practice?
Well, I think that the transfer on death deed is probably cleaner in a lot of instances, because if you transfer the life estate, you retain a life estate, I should say, and then the remainder interest to adult children. What ends up happening if you want to sell that house and move somewhere else, you've got to you have to sign the deed, but then also you got to get your adult children who have a remainder interest to sign the deed that transfers the house to the purchaser. And so from a practical standpoint, it can have some issues there. But if you have a transfer on death deed, you continue to be the sole owner, or you and your spouse continue to be the only owners of the property, and it only transfers on death. And so you still maintain all the control that you would otherwise want to have with your real estate. And so from a practical standpoint, I end up doing more transfer on death deeds than life estate deeds. From that perspective, that's probably my my preference and how I do my estate planning for clients.
Yeah, and I agree with that. I think it's really an interesting opportunity, because if your larger asset is your house, and for most Americans, that's one of their largest assets at the appropriate time. If you're able to essentially transfer most of your asset base automatically, and you have your will in place, you may not need to open up a probate estate at that time. There's other reasons to open one up, but if that asset base is less than the small estate exclusion at that time, then you wouldn't necessarily be required to go through probate court. And again, those situations are fact dependent. You want to kind of walk through those if that's something you're interested in and want to put a plan together like that. But the transfer on death vehicle for a deed is really a helpful way to move things at the appropriate time. And it still gives that same kind of benefit of protection of the individuals involved and control, which is a big thing.
Right, right. Well, I think that about sums it up for today. Seth, how can we get in touch with you?
Thomas, I'm up in the heart of Hamilton County in Noblesville, Indiana, and our website is noblesvilleattorney.com. And I noticed something that was pretty cool on your site as I was looking through the dog blog digest today. We'll switch those words around. And if you scroll down to the end of the article, I see that I can book an initial call with you right from your website. So that's pretty cool.
That's right. Yeah, so you can go to my website and you can book a call. You can actually get directly on the calendar, and you can have the option of doing a phone consultation with me or a Zoom consultation with me. So you don't have to necessarily come into the office. But yeah, so vicklaw.org is the website. My name's Thomas Vick, and I'm located in Greenwood, Indiana. We do estate planning, elder law, and estate administration work, and we'd be glad to help you if you're somewhat on the south side of Indianapolis, and if you're kind of on the north side, go to Adler Attorneys. So, Seth, as always, we appreciate it, and we'll see you next time.
Sounds good, Thomas. See you.